Joining us again in the studio is Brent Haynes, attorney, political analyst, and Catholic speaker on pro-life issues and religious liberty and such cases. Good morning to you, Brent.
Good morning, Joe.
Well, we got to turn that phone. Good morning to you, Brent.
Good morning, Joe.
Now it works. Praise be to God. Good to see you back in the studio. We always we go to you for the Supreme Court stuff. You're very well tuned into that, and I know it's kind of a big deal when a Supreme Court justice decides to retire just prior to the midterms. That seems like a big deal.
There was speculation about pressure put on Stephen Breyer because of his age to retire to give the Democrats a chance to put a much younger justice on the court. The trend in recent years, probably going back into decades now, probably going back about 20 years or so, has been to put younger and younger justices on the Supreme Court. We've reached the point where we no longer put wise old men and women on the court because of their age and experience. We put young people on the court because of their judicial philosophy and hope that they'll stay there for decades. So whether he really wanted to retire or not, Stephen Breyer retired, and Joe Biden got his appointment.
So the thought was after the midterms, they may not have the votes to get this through.
They were certainly calculating that, Joe.
They're not confident going into the midterms. Golly gee whiz, lowest job approval ratings ever, apparently, for a U.S. president.
And this nominee, Ketanji Brown Jackson, was approved by the Senate less than a year ago for her appellate court position.
Oh, I see.
She was approved only by a vote of 53 to 44. The Democrats have to hold all 50 of their Democrats, and then, of course, the Vice President, Kamala Harris, can break the tie. She got 3 Republicans last time. The reality is that, there are 3 main points, on Ketanji Jackson, and one of those is she'll almost certainly be confirmed. The Republicans would have to be united, and a Democrat would have to defect, someone like Joe Manchin, and who's already indicated he would probably vote for somebody more liberal than himself, and Kirsten Sinema from Arizona is probably going to vote to confirm. So even if some of those Republicans who voted against her before, such as Lindsey Graham from South Carolina, decide, as he has suggested, to go against her this time, she's almost certainly getting on the court. Professionally, she's qualified. She's got the credentials. She went to Harvard undergrad. She got a Harvard law degree. She served on the U.S. Sentencing Commission as vice chairman under President Obama, which is a clue we can come back to in a moment about her judicial philosophy. She served for 8 years as a federal district court judge, a United States district court judge, which of course means she was again approved by the Senate. But just last year, President Biden nominated her to the D.C. Court of Appeals, and as some of your listeners probably know, the D.C. Court of Appeals is the most prestigious and many consider the most important court of appeals in the United States, second only to the Supreme Court. That's because it handles a lot of cases that involve challenges to the federal government. If you're going to sue the federal government, often you have to file suit not always, but often you have to file suit in Washington, D.C. So look at what President Trump did. He got Brett Kavanaugh from the D.C. Court of Appeals. John Roberts came from the D.C. Court of Appeals. It's becoming a real stepping stone to the U.S. Supreme Court. So she's already been approved. She's already had the background check. The only thing to really look at now is her judicial philosophy. Since the days of Robert Bork, when he was nominated by President Reagan in the 1980s, these Supreme Court nominations have become very politicized, as we have seen just in recent years with Amy Coney Barrett, with Brett Kavanaugh, because people finally woke up to what is at stake. These are lifetime appointments. Once you put these people on the Supreme Court, there's nothing you can do to get rid of them. Yes, theoretically, you could do an impeachment, but that would be an extraordinary act. And judges and people who want to be judges become very good at hiding their real judicial philosophy. And it's hard to distinguish between their personal beliefs and the beliefs of the clients they represent, though that's another clue with Jackson we could talk about briefly. And when they write opinions, sometimes that'll give a clue. I think we have some from Jackson's opinions. But again, they're supposed to be constrained by the law. They're supposed to be following the law. Once they get on the Supreme Court, they can do what they want.
Yeah, pretty much. Well, what do you make of requiring it to be a female and requiring it to be a black female at that?
There's been a lot of criticism on that. Honestly, I think that a lot of that is just political criticism. Let's remember that Ronald Reagan made a promise to appoint the first woman to the U.S. Supreme Court. And at that point, only men had served on the Supreme Court. This was in the 1980s. We're only talking about approximately 15 years or so after the beginning of women really entering the workforce in large numbers, entering the legal profession in large numbers. And it's, you can make an argument that it was time for a woman to be on the Supreme Court. You don't have to buy into identity politics the way it's played up by the political left these days to understand that, maybe it was time to put a woman on the court. That's not my problem with Joe Biden's appointment. My problem with Joe Biden's appointment here and with some of his other appointments, which is a real clue to her philosophy in all likelihood, is he has a record already in a little more than a year in office of appointing real radicals.
Yes.
Well, also, I mean, just playing devil's advocate a little bit, just because Reagan did something doesn't make it okay. So just because Reagan comes out and says, "Oh, I'm going to appoint a woman," ahead of time doesn't mean that's a good idea, because shouldn't this be a meritocracy, the best person for the job? I mean, if it happens to be a woman, well, then that's something that can be discussed whenever it's appointed. But to preemptively say it, how does this not violate discrimination laws?
Well, it doesn't violate discrimination laws because the president, under the Constitution, gets to appoint whoever he wants. In fact, he doesn't even have to appoint a lawyer to the U.S. Supreme Court.
I could be appointed.
Why did
could
I
be
get the
appointed.
call then?
I know, that's what I'm thinking. I'm like,
Sounds like a cush job.
I identify as being qualified, so there you go.
Yeah, it's no. You make a good point, Adrian. I mean, somebody can certainly make those arguments, but this argument that you want the best person for the job. Look, we're a large country. We're a talented country, a wealthy country. There are many, many people who are qualified to serve on the Supreme Court. Every president has his choice or her choice when the time comes to appoint more than one. They have many candidates they can appoint. I think it's good to point out that Joe Biden committed to appointing a particular person of a particular gender and a particular color in the context of his larger identity politics practice.
Yeah.
Why did he appoint somebody with absolutely no background or education or training or apparently skill to be Secretary of the Department of Transportation? Well, because he wanted to check a box on his identity politics.
Yeah, that's pretty obvious. But I want to get into as Catholics, how do we see this pick? I mean, I want to get in more into that, but we're down to just about a minute here. We'll have to do some more on the other side of the break.
Yeah, she has represented abortion rights groups. Now, that could just be representing a client when you work at a law firm at the beginning of your career, but what's really troubling is that she wrote an amicus brief, which is usually something you volunteer to do. And she wrote it to support the Massachusetts law that would prevent anybody from approaching within 6 feet of a vehicle or a person entering an abortion facility. Now imagine doing that at a political polling place where you wouldn't be allowed to go up and hand somebody campaign literature, for example.
Yeah. Let's talk again. Let's go into the philosophy of this Supreme Court nominee. As a Catholic, we would have some issues with her beyond just her gender and or race.
Yeah, as we discussed before the break, she has a record of representing abortion clients, but it's not just that. I mean, she's shown some real evidence of being not just liberal, but very liberal across the board. When President Biden came out and announced her, one of the big debates, he made a comment that was revealing, one of the big debates about constitutional interpretation is whether we should adhere to the Constitution as it was written. There are people who consider themselves originalists, people who consider themselves textualists. You read what's actually there. Then there are those who are usually more liberal who want to talk about whether the Constitution is a living, breathing document. Now, when she came up for her district court nomination, she said she didn't follow that principle, which was good. Last year, she dodged the question, talked about the importance of judicial independence, which is not the issue there, and she used the phrase, the Constitution is an enduring document. Well, you can easily interpret it to be the same thing. And here's a real giveaway, Joe. If you go back and you can look at this on YouTube, when President Biden announced her, He comes out to the lectern and he says that it is important to have someone who has a historical perspective to understand that the Constitution is a resilient Charter of Liberty. And that emphasis on resilient, Joe Biden emphasized that word. So she believes in an enduring Constitution. He understands her to believe that the Constitution is a resilient document. So she's almost certainly going to take a very, let's say, flexible approach to interpreting it. Another issue is, Senator McConnell reportedly asked her, the nominees make the rounds of a lot of the senators. Senator McConnell is the Republican leader, so he's very important, obviously, and he asked her what she thought of court packing. Now, judges just notoriously get away with not answering questions about particular issues because they always say, well, look, I might have to vote on that issue in the court, and I can't really prejudice myself. And a lot of times that's legitimate, but a lot of times they really use that as to duck.
Yeah.
She apparently refused to answer McConnell's question, and the point here is that Ruth Bader Ginsburg and Stephen Breyer both spoke out against court packing. And she has refused her first opportunity to repudiate that idea.
So maybe this is the long-term strategy here, because one of the questions I was going to ask is, isn't this she's just going to replace a liberal justice anyway, so isn't this just neutral here? I mean, there's not a gain here, but you're suggesting there's a strategy.
Well, yes, when you count the votes on individual cases, it's still going to be a liberal vote for a liberal vote. The difference here is, and I could be wrong, it could be that she really is in the mold of Breyer. And Breyer himself is pretty liberal. Remember, Breyer, in the Pregnancy Help Center case from California a couple of years ago, California wanted to essentially commandeer the speech of pregnancy help centers and make them advocate for abortion, essentially. And they had all kinds of just absurd requirements that would have prevented the pregnancy help centers from being able to put up billboards effectively, that kind of thing. Breyer supported that law.
Wow.
So he's pretty far liberal. Now, Ketanji Brown Jackson, what she will do, although she'll only be one liberal vote, and right now one of three on the court, she's going to push the boundary of the liberal jurisprudence in the court further to the left. And she will write dissents. Now, dissents, by definition, aren't the deciding opinions in a given case, but what they do is they lay the groundwork for future opinions. So a liberal or a conservative justice writes an opinion today that's a dissent, and then 5 years from now or 10 years from now or 20 years from now, a justice in the future and a majority of the court, they pick up on that because the law's all about precedent. And they say, back in the year such and such, Justice so-and-so wrote this. That is how we got Roe v. Wade in many ways. Now, there were majority opinions that obviously led up to Roe v. Wade, but you begin by planting the seeds of jurisprudential thought in the opinions, and she'll probably almost certainly push the court, further to the left. An important clue about how liberal she might be is to look at Joe Biden's other appointments. I mentioned that earlier. Consider some of his other appointments in terms of philosophy. He appointed a Soviet-born, Soviet-trained, Soviet-educated woman who's a self-described radical, Soleil Omarova. What could go wrong? Appointed her to be controller of the currency.
Yeah, that's fun.
And she eventually had to withdraw. He's nominated Sarah Bloom Raskin for the Federal Reserve. The Federal Reserve provides money for the banking system. She wants to turn it into a regulatory agency that would essentially stop banks from lending money to companies that develop energy for us, unless it's green energy.
Yeah.
I mean, Biden has nominated very, very progressive, far-left people to important positions. Why would he do anything different here? And consider this. The progressives who are in control of the White House, who help develop these policies for the president, and that's their job, who help develop these policies, who come up with these appointments, they wouldn't be doing their job for their position if they hadn't vetted their opportunity, their huge opportunity for a Supreme Court nominee. You know very well that they have almost certainly gone over everything closely to see who supports her, to see what she really thinks. One other quick clue is from her own writings in her judicial opinions. She's used some pretty inflammatory, overly argumentative language in opinions. She ruled against President Trump in a case where she accused President Trump of, using a Ouija board or a magic 8-ball to make a decision. That's just not mature professional judicial writing.
Brent, I'm wondering, there's a potential for Roe v. Wade being overturned in the near future. Is this nomination something that could prevent that from happening?
Not this term, because first of all, she won't be in office this term.
Oh, okay. Praise God.
And good for that. But remember, Breyer's not going to vote to overturn Roe v. Wade either.
Right.
That gets to the cases that are pending on the Supreme Court now. There are three really big ones to look at. Dobbs is the Supreme Court case. That's Dobbs versus Jackson Women's Health Organization. And that's the case that's a real conundrum, because there's usually the Supreme Court, all courts like to take a middle ground if they can, especially when you have several judges voting and it's a very contentious issue, especially if it's an issue where the whole country is involved, it's a moral issue. You want to perhaps try to move the country one direction or the other, but maybe not all at once. Mm. And it's difficult to do in the Dobbs case because it's hard to just strike a middle ground. What's the Supreme Court going to say? Okay, no, we're going to change it from 20 or 22 weeks to 18 weeks or 16 weeks. It's difficult. They pretty much have to go up or down on that viability issue. Mm. And that's why conservatives and pro-lifers, of course, are very excited about that opportunity. In terms of the vote total, though, she's simply, on that issue, when you count the votes, although she's possibly more radical than Breyer on abortion, it still comes down as a vote for Roe.
But that has that decision already been made, and they're just waiting till June to tell us?
We don't know, and we may never know, or we probably won't know for years or decades. With the Supreme Court, and this is to the Supreme Court's credit, it's one of those institutions where there are not a lot of political leaks. In fact, there are almost none. Very, very few. It's 9 justices, it's a small number of people. They have a small number of clerks who work for each of them, and they shouldn't be out there talking. So we don't know if they've already taken the vote and they're drafting opinions, but what will happen is they're all preliminary votes until the end, essentially, because they'll circulate opinions and justices will try to write opinions to win over other justices.
Oh, wow.
So, and that's a regular part of the Supreme Court. So the justices could be trying to win each other over to certain positions in how to construe that case. The Supreme Court usually hands down its biggest decisions right at the end of the term, probably so that they could head out to their chauffeur-driven cars and get straight to the airport. But it'll probably come down in June. But Breyer's going to vote to uphold Roe v. Wade, of course.
Wow.
Really, Planned Parenthood versus Casey.
Let's pray that actually happens. We were discussing this yesterday after the show. Like, Adrian and I were, what happens in a post-Roe v. world, with the pro-life movement? We may have some more guests on next week to discuss that and sort of brainstorm that a little bit. But let's go back to this nominee. If she gets on to the court, and you're saying it's very likely she will, do you see court packing in the future?
That's the worrisome thing, and that's the Dobbs case is relevant to that. If the United States Supreme Court does hand down a decision that ends the abortion regime as we know it or significantly impairs it, that is going to be exhibit number one by the far left, even by just moderate liberal Democrats who just believe in abortion as what they call, reproductive rights. That's going to be exhibit number one to show the American people that the Supreme Court is out of touch with contemporary America. Mm-hmm. They will use that as an argument for packing the court, and that's dangerous. And that's why we should be worried about this opinion. It does us no good if we outlaw abortion in June through a Supreme Court opinion, then have a whole series of other lawsuits across the country about implementation of the new abortion laws. And in the meantime, the far left is able to capture the court with a court packing scheme, because if they capture the court, the Dobbs case would be overruled, and abortion would be with us for the rest of our lives, probably permanently. And not only abortion, but all of the other far leftist schemes they want to do, including anti-religious liberty issues, two of which are before the court right now. So watch for that. If the Dobbs comes down, watch that to feed the court packing argument. Now, one good advantage, and this is really something only happening in God's providence, right? God can bring something good out of misery. We've got high inflation in the United States, the highest in 40 years. We had the disaster in Afghanistan where 13 servicemen were killed, almost certainly unnecessarily. We've got all these problems in the United States, low approval ratings for Biden. This might be the year where the Supreme Court could end the current abortion regime without the Democrats or the progressives being able to use that issue to carry them to victory in November.
Wow. Well, we're going to have to leave it there. Brent Haynes, attorney and Catholic public speaker. If someone wants to book you to give a talk someplace, how do they do that?
They can just send me an email, Joe, at brenthaynes@outlook.com, BRENTHAYNES@outlook.com.
Brent Haynes at Outlook.com. We'll put that in the chat as well. God love you, Brent. Thanks for your time today. We're very grateful.
Thank you, Joe.
All right, that's going to do it for hour number 1. Praise be to God. Thank you for joining us this hour. We're grateful that you were here.